Welcome to the Chase MedSearch podcast, the place where we dive deep into the medical device sales industry by discussing the current trends, timeless philosophies, and amazing experiences that shape our niche of the industry. Join me, Jordan Chase, on a guided tour as I speak with established sales leaders and professionals as they share stories that will help you get in, stay in, and thrive in your medical device sales career. Let's start the show. Welcome back to the Chase MedSearch podcast. Trying to keep a regular rhythm, as I always say. I love hearing from listeners. Please reach out to me with feedback, comments. I expect this one will be one that will be widely shared, discussed, talked about, maybe debated. Please feel free to get back to me with commentary, questions, anything like that. Love having dialogue with such an active, participative audience. I've got a phenomenal guest today, Beth Bertelson, owner and attorney at Bertelson Law Offices in Minneapolis, Minnesota. Beth has practiced exclusively in employment law since 1990, representing both employers and employees in all areas of employment law, including but not limited to harassment, discrimination, retaliation, accommodation for disabilities, employment contracts, non-compete agreements, which we're talking about today, non-solicitation, confidentiality agreements, non-payment of wages or commissions, leaves of absences, unfair discipline, and hiring and termination claims. She's mediated cases for the Minnesota Department of Human Rights, the Minneapolis Civil Rights Department, and the National Arbitration Forum. I have known of Beth for some time now, even though we recently just actually connected live, because so many people that I respect have worked with Beth in a number of capacities. I've heard her name a lot. Beth is, as I've found her to be, humble, modest about her accomplishments, but she is a titan in this space, and she knows the medical device industry very, very well. I will not name some of the companies that she has worked in conjunction with or employees from those companies, but we would all know who they are if I mention them. Beth, welcome to the Chase MedSearch podcast.
Well, thank you very much for having me.
I am delighted that you were willing to come on and talk. A disclaimer for this conversation for our audience is we are not offering legal advice in this conversation. This is for informational purposes only. I am not a lawyer. Beth is a lawyer, but she's not your lawyer. And my company is not a law firm. So this is, again, only for informational purposes. Beth, let's talk just a little bit. I gave an intro on your background, but I know my audience would love to get to know you a little bit better. Where are you from? A little bit about your education and career history. Just fill us in on the Reader's Digest version of it.
Sure. I am from Minneapolis, Minnesota, and all of my education has also been in Minnesota. I attended St. Olaf College and received my undergraduate from 1980 to 1984. I graduated from William Mitchell College of Law and received my JD in 1987. And as you said, I've been an attorney for 37 years, 34 of those years working as an employee rights advocate. I also serve as an arbitrator and a mediator. And I have, in that capacity, represented hundreds of employees that have had their careers restricted in one way or another with a non-compete or non-solicitation. And we have worked to advise them surrounding the language or negotiate around restrictions or work to narrow the language at the beginning or the end of a relationship.
Fantastic work. And you've done it well. I know people that have benefited personally from your work. The subject matter at hand, the FTC dropped a bomb on April 23rd by issuing a final rule to promote competition by banning non-competes nationwide, which their language said it protects the fundamental freedom of workers to change jobs, increasing innovation, fostering new business formation. The only exception they made is senior executives who represent 0.75% of workers. After this ruling, my phone started to get some serious text messages. Did yours?
It did. We received numerous phone calls from both prospective clients and our current clients. We represent a number of executives or high-level individuals that are subject to non-competes. And the questions that we were receiving included, is my non-compete no longer valid? Or how will this ruling impact my restriction in the future? So a number of concerns about the impact surrounding their contracts going forward.
Yeah. Same with me. I got a number of questions. People said this must be good for your business. I think we were all trying to understand what it meant at the time. And I know it takes effect, I think, 120 days from the issuing of that rule. Do you know off the top of your head what date that means that this rule will be effective?
That is September 4th, 2024.
Okay, there you go. What in layman's terms, because I would bet everybody listening to this podcast is a layman. They're probably sales reps, sales managers, clinical support people, marketing, sales training individuals. Probably very few lawyers listen to my podcast, but I know a number of recruiters do too. In layman's terms, what does this mean?
This means if it goes into final effect, that employers for millions of people can no longer have bans on post-employment ability to work in a competitive field.
Got it. So that's what it means. There's no restrictions anymore. Is that right?
Well, this ruling, one, is going to be subject to a lot of litigation, and it doesn't prohibit non-solicitation of customers, non-solicitation of employees, agreements designed to protect trade secrets, agreements designed to protect confidential information. And I think this is where, if this law goes into effect, then employers will work to use some of these other avenues to restrict employees in the future. And that's where I think your audience would need to be savvy and thoughtful about what they sign and how they go about reviewing any documents put before them.
Mm-hmm. And I'm thinking the number one issue for my audience is customers, right? So if you walk out, I'm going to use a company name. I'll use Abbott. If you work for Abbott one day and then you choose to go to a competitor of Abbott, let's say you go to Medtronic the next day. So now you were an Abbott employee, a sales employee. Now you're a Medtronic sales employee. Did you say that there is a restriction on calling on former customers, or that's going to be what's going to be determined by litigation?
Well, what will happen, I believe, is that your audience's agreements likely have a non-compete agreement, so that language that says they cannot work at a competitive industry very broadly. But in many cases, the agreements that have been signed will also say that they cannot solicit or go after any current clients for a period of time. And so that's where the FTC ruling will not restrict that ability of an employer to put that kind of restriction on employees. But having said that, if the non-solicitation of customers is so broad that it works in effect as a non-compete, I do believe that courts may have concerns that it is simply just a non-compete in disguise.
Mm-hmm.
But that's where an employee really needs to review the agreement, needs to look at the language to see if the customers that are defined are so broadly defined that it's really not fair to them and their career, and it puts them on the bench going forward.
Mm-hmm. I'm thinking of, California's had for a long time a situation where, the general sense is non-competes are not valid. They can't be enforced there. They're not worth the paper that they're written on. I've heard it all. And we've seen over the years, sales employees walk out one day and come in the next day and work for the competitor and call on all the same customers that they called on before. And there really, as far as I'm aware of, have been no issues doing that. Would that, in your mind, if the ruling means what it says it means, would that now be the case in places like Minnesota, South Dakota, Florida, Georgia, all kinds of other places where there's just now, they were calling on Good Samaritan Hospital one day for a company. Now they're calling on Good Sam for a competitor selling basically the exact same product just for the competitor. Is that going to be an issue? Because that's more specific, right?
Right. It will be an issue in that, based on the language of the ruling, it really is confined to non-competes. So working for a competitive company. It doesn't restrict employers from requiring employees to sign agreements that says they can't go after certain customers for a period of time.
Mm-hmm.
So even though certain states like California, Oklahoma, Minnesota, and North Dakota have full bans on non-competes, that doesn't restrict the non-solicitation of customers piece.
Got it. So we're distinguishing here between a non-compete and a non-solicitation clause, which might be contained in a non-compete that says, hey, you can go work for anybody you want to, but understand you can't solicit current customers for a year.
Right, right. And that's my advice, where it would be helpful for individuals to seek advice from an attorney at the front end, to see at the time when employers are excited to bring you in, and try to limit the restrictions surrounding non-solicitation of customers.
Yeah, because the employer might be excited and say, great, we are now going to vacuum up all the competition's business. Well, you can hire that person, but they may not be able to pull in their top 5 accounts for at least a year, or maybe 2 years sometimes. I've seen that written in as well, until that non-solicitation clause that was in the non-compete expires. Is that right?
That's correct.
Yeah. Well, the FTC added that they think this is going to drive up wages by another $500 or so per year for employees, lower healthcare costs by almost $200 billion over the next decade, add more dynamism to the American economy, increase patents from 17,000 to 29,000 new patents each year for the next 10 years, and create more than 8,500 startups. I mean, it makes you wonder, why'd they take so long to do this if it's going to fix our economy in all these amazing ways?
It is significant, and it is a big deal, but there has been significant debate. The ruling only passed by 3-2 among the commissioners. And the debate among businesses is that the ruling violates their right to contract with employees. Businesses argue that employees are given an appropriate consideration for the restriction. Businesses invest in employees and they have the right to protect their legitimate interests. And then among the conservative judges, and especially the Supreme Court, they have become more and more concerned about administrative agencies' abilities to make law. They argue that these administrative agencies are not elected officials and they should not be able to create law. So again, I think it would be great if people can advocate in their states to try to get more bans on non-competes. I think this ruling will have significant litigation surrounding it, such that, again, the audience should really be concerned and not simply sign an agreement with the belief that on September 4th, 2024, there will be no kind of restriction on them to compete in the future.
Yeah, and I think that's what's so helpful about your comments around non-solicitation, because I'm just keeping my audience in mind here and thinking that that hasn't changed from what we're talking about. That's still going to be an issue. And primarily, a lot of times, that's why companies won't make competitive hires, because they could hire somebody and now that person may have the right skill set and mental ability and all the things, the experience to sell in the neuromodulation space, for instance. But if they hire that person in a market that maybe doesn't have sort of a huge customer base, well, now what are they going to do with that person? Because they can't call on customers in that market. They're sort of on an island. They're going to have to drive 5 hours somewhere where they can call on new customers that they don't know and have never called on. So it's not the panacea that it first appears to be to some people.
Correct. I think we have cautioned our clients. We have continued to suggest they need to be concerned about language beyond the non-compete. And so many people call me, Jordan, and say, I'm under a non-compete, but they're not valid, right? They won't be upheld. And that's simply not true. In Minnesota now, there is a statute that went into effect on July 1st, 2023. It's Minnesota Statute 181.988. And that does not invalidate existing non-competes, but non-competes going forward after July 1st, 2023 are invalid for everyone, even top executives. It's only valid upon a sale of a company or between a franchisee and franchisor. So more laws like the law that just went into effect in Minnesota would be wonderful for other states. There are a number of different states that have adopted different forms of non-competes. Would you like me to go into some of those other states?
I would love that.
Okay. So in Colorado, we've talked about California, Oklahoma, Minnesota, and North Dakota all have full bans on non-competes. Colorado, Illinois, Maine, Maryland, New Hampshire, Rhode Island, Virginia, and Washington have non-competes related to certain incomes. So if your income falls below a certain level, in those states, non-competes are not allowed. In Iowa and Kentucky, there is a limited use of non-competes for certain healthcare workers. So if you're a healthcare worker in Iowa or Kentucky, the use of non-competes is not allowed. And then Nevada prohibits non-competes for hourly workers. And in Massachusetts, non-competes are required to be supported by consideration. So in Minnesota, that used to be the case maybe 20, 25 years ago. If you worked at 3M and you signed a non-compete and you couldn't find a job because of the non-compete, the employer would pay you a sum of money. And maybe that is what your audience needs to think about. If a non-solicitation or other restriction going forward is such that they really imagine that it will impact them going forward, they need to think about contracting for the loss of money when they're sitting on the bench.
That's a good point. So right at the start, before you sign that agreement,
right?
Maybe when you're being hired, or if they're trying to maybe renegotiate your non-compete or your employee agreement or something like that, especially in small markets. I'm thinking about, like Reno, Nevada, or somewhere like that, which great medical market, but it's not a big medical market. And there aren't jobs that flow through there all the time. And so now if you're restricted from calling on customers that you know and have done lots of business with, or hospital systems that are there, what do you do if you've tried to change employers and now you can't find a job and your non-compete's holding you back?
Right. I recently advised a sales executive that had a very restrictive and broad non-solicitation provision. And he said that in effect, that in his field, because it was so limited in terms of who the customers are, it really was in effect a non-compete. And that's where I was discussing earlier. A court might say, no, you're just trying to work around the prohibition on non-competes, and this isn't allowed. But we can't be certain how that will go.
Mm-hmm. Yeah. Well, we've seen some companies issue non-compete agreements that are very broad, national in scope, and last for 2 years. I've seen those before, and I think, doesn't it come down sometimes to a question of enforceability? If that's so broad, so national in scope, and so prohibitive, and especially with a large company that has a number of competitors out there or spaces that they compete in, it can appear to be really, really restrictive on the surface, but it also may not actually be enforceable.
Right. And I think what people need to think about is the reality of who's going to move forward with the lawsuit. Will the company send you a cease and desist letter? And then will they move forward with a temporary restraining order or continue to go forward with the case? And that comes with some expense from attorney fees.
Mm-hmm.
And I think companies will analyze whether it makes sense, whether they'll move forward with it. I generally talk to my clients, though, do you want to sign an agreement at the beginning without really thinking through, just betting on the employer not moving forward with that? Or would it make more sense to try to refine what's being presented to you? And I get that we're excited when we get an opportunity. We want to start with good feelings on both sides, but I think you can do that and be professional and thoughtful about the future as well.
Mm-hmm. I think employers are required to notify employees of this decision and their status as it relates to non-competes under the ruling. Is that correct?
That is correct. Assuming that the final ruling will become effective September 4th, 2024, employers do need to notify employees that their non-compete is no longer effective.
Mm-hmm. And they gave language to employers that they can use to communicate that.
Right,
Mm-hmm.
right. So this is a very big deal. And I don't want to be completely negative in terms of our courts, because this does affect an estimated 30 million employees who are under non-competes. So 1 in 5.
Yeah. It's standard now. I think almost every client I have or have worked with in the past 12 years, they all have them. You said if it becomes final, is there anything that could block it? Anything that could hold it up? I mean, it seems like the FTC voted on it. The commissioners issued their statements on it. It was a 3-2 vote. It was close, but it went through. What could stop it?
Well, the day it was announced, there was a lawsuit filed in the Northern District of Texas to fight the ruling. So, that could make its way to a very conservative Supreme Court, which does not like administrative rulings. The hope is that people on both sides realize that this is better for the economy, for people to be able to work in a number of industries and to have the freedom to do that and not be on the bench and to have competitive salaries. So that is the hope.
Who filed the lawsuit? Do you know?
I am not sure, but I do believe it was part of a business, sort of a business pack.
Okay, like a consortium of like you said, a PAC, right?
Mm-hmm.
That people pay money into, and then they kind of expect this organization to act on their behalf.
Right.
Something like that. Okay, yeah. If there's a violation of this rule on non-competes, what recourse do employees have?
Well, employees could go to court and bring a temporary restraining order. And I think what would happen is, how this would get started is that the employer may attempt to reach out to the new employer and ask them to stop and to cease. I think then when they're educated, the employee may not need to bring anything to court because the employer will learn that what they're trying to do is not lawful.
Mm-hmm. I did a little research on that, my question to in advance. There is an email called noncompete@ftc.gov, Foxtrot Tango Charlie.gov. So if there's a suspected violation of the rule, market participants can report information there to the Bureau of Competition.
Right. And since the ruling went into effect, the FTC has made several rulings on cases and found that employers had illegal non-competes. And those were some interesting cases. In those cases, there was a case where the FTC on March 15th, 2023, ordered a glass container company to drop non-compete restrictions on more than 300 workers across a variety of positions. I have a couple more of those where the FTC made rulings. One, there was a complaint in September 2023 that was brought against a medical spa.
Hmm.
And they actually went farther than just the non-competes in restricting these employers. In that particular case, this was a NLRB, so National Labor Relations Board, brought a ruling that this medical spa violated the National Labor Relations Act by maintaining unlawful confidentiality, non disparagement, non compete, non solicitation provision. So, arguably, with the current administration, the tide is turning. We don't know how that might change with new administration, but I mean, that's a good sign. And there's a couple more of those types of decisions where the National Labor Relations Board was another avenue for employees to fight these kind of ongoing restrictions and restrictions beyond just the non-compete.
Yeah, that's one thing I wanted to talk about maybe before we wrapped up, because there's a lot of confusion around a couple terminologies. One is non-compete agreements, and then the other one is they're called by several different things, but most typically term agreements. And term agreements, in my experience, have been a contract. It's different than a non-compete where that's just kind of issued to the employee when they start their employment along with everything else, and they sign it or whatever, and it goes in a file. A term agreement in the last few years we've seen where, companies are willing to pay sales reps, sometimes clinicals, a certain amount of guaranteed money for a period of a year to 2 years, sometimes 3 years, in exchange for them not going anywhere. It's a contract, which is different, in my opinion, I don't know, not a lawyer, than a non-compete. Term agreement might say, for example, to a sales rep, we're going to pay you a guaranteed $300,000 per year for 3 years, regardless of how much you sell. In exchange for that, you don't go work for not only just a competition, you don't go sell Mazdas, you don't go work at Baskin Robbins, you don't go anywhere. You work for us. And if you leave before that's up, you pay us that money back. That would be different, correct?
Yes and no. I think to the extent that those types of agreements work as non-competes, I think a court would find those currently, at least in Minnesota, to be invalid. If it is something where it is an ongoing relationship that they're trying to enforce, I have represented people and we've negotiated out of that type of language at the back end. And it typically, the negotiation surrounds me understanding the details of my client's employment situation and what types of facts could provide leverage to get out of those agreements, whether there was something unlawful that the company was doing, whether my client had some kind of medical condition, or simply the employer and the employee wanted to maintain a relationship going forward, but their relationship was no longer workable. And both parties decided to contract out of the original agreement. I don't know if that's helpful.
It is very helpful. And I think the bigger point with what you said is things that appear to be ironclad may not be ironclad.
Correct. I have found that if my clients are professional and direct about certain requests, or I work with the in-house attorney in a professional, direct way, that most times the parties want to maintain a relationship and we can create workarounds for these situations.
Terrific. I want to go back real quick because I wanted to talk about the difference and the overlay between federal law and state law as it relates to non-compete agreements. Because obviously the FTC, Federal Trade Commission, that's a federal ruling versus a state ruling. Can you talk about how those relate to each other? So if someone lives in Minnesota, and obviously Minnesota has an advantageous situation for non-competes, how does that work or interact with the FTC's ruling? because it seems somewhat state dependent as well for the employee.
Sure, sure. Let's take, for example, the Minnesota statute. In Minnesota, the statute also states that an employer can't have a workaround for a non-compete by having an agreement that references other states' law. So if you look at your employment agreement, it's typical at the end of it to have a provision that the laws of Texas, for example, will pertain, despite the fact that the employee lives and works in Minnesota. So the Minnesota statute outlines that this does not have the effect of reversing this ban on non-compete. So that's a good thing for Minnesota residents and people that work in Minnesota. So with respect to the federal ruling, let's assume that it goes into effect. It's a wonderful ruling and will have the impact of affecting individuals in the entire country and not just a state. I think I was speaking about the benefit of having all these state statutes that ban non-competes because I see that they're less likely to be fraught with court fights because I see the FTC ruling will have potential court fights nationwide, and individual states would have more control of the different statutes because they have been determined by an individual legislator.
Got it. That's really helpful. So it sounds like the state would be more important in terms of their position on non-competes than the federal, but the federal is sort of a blanket provision for all employees in the country.
Right. I mean, it would be wonderful if it goes into effect and there are no fights and it continues to be in effect. Then it will affect all employees. I should note that there have been 2 bills that have come at the federal level that have the goal of having the same sort of ban on non-competes. And one is called the Workplace Mobility Act of 2023, and the other was the Freedom to Compete Act. And neither have passed in Congress, but both show that there has been a sea change where it seems like the public is becoming more and more aware of the negative impact of these non-competes.
Yeah, it's certainly front page news. And, in the medical device industry, I can think of several individuals that made the cover of Wall Street Journal, maybe within the last 10, 15 years, based on their non-compete status and sort of their transition to competitors. So in the medical device space, it's been hot for a long, long time, as you know, and especially when you have really highly skilled sales professionals that really become embedded in their customers' practices, become extension of their customers' practices, are, in bar mitzvahs and weddings and all kinds of things where they're very closely tied to customers. And the customer does business sometimes with that company simply because of who their representative is.
Exactly.
And that is going to remain a super hot topic, I think, in this niche of the industry. I would love to invite you back, say around September, once this takes effect, and have you as a repeat guest to talk about how this is all spinning out.
That would be wonderful. Thank you very much for inviting me.
Oh, it's been fantastic having you on, Beth. How can people get a hold of you if they wanted to? And I mean, I assume with lawyers, are you limited to practicing in the state that you're licensed? So you would be able to talk to people or work with people that are in Minnesota. Is that right? Do you hold any other licenses?
I would. I can be reached at beth@bertelsonlaw.com or 612-278-9832. And if you have members of the audience that are in other states, I'm involved in the National Employment Lawyers Association, so I could help them with referrals as well.
Wonderful. Wonderful, Beth. Thank you so much for having been a guest on this podcast. I've been wanting to have you on for a while, and I'm so glad you agreed to do it.
Thank you very much.
Thank you for joining us on the Chase MedSearch podcast. I hope that you gained some helpful insight from today's episode. If you enjoyed this episode, be sure to subscribe so you don't miss future episodes, and give us a like on your favorite streaming platform. It really helps grow our audience. For more information on Chase MedSearch, visit our website at chasemedsearch.com. Thanks again for joining us. Until next time, I'm Jordan Chase, and this has been the Chase MedSearch podcast.